Hello, everyone. Let's talk about the Supreme Court case of Int'l Shoe versus Washington. This is a huge case for personal jurisdiction, and if you're in civil procedure or you're litigating in the federal court system, you are going to need to know Int'l Shoe because it is very relevant and it gets talked about all the time. So, this was an opinion by Chief Justice Harlan Stone. It was unanimous. Every member of the court who was hearing the case agreed. So let's talk about the facts. The background is not super relevant. It's mostly the law. But what happened was that Washington created a tax on employers who do business in the state. The tax would function as a mandatory contribution to the state's unemployment compensation fund. And so the business Int'l Shoe was not actually there inside Washington state. They were incorporated in Delaware and they had a principal place of business in Missouri, but they had a staff of 11 to 13 salesmen in the state of Washington. Now, Int'l Shoe decided not to pay the tax on employers that Washington had. So the state of Washington, of course, sued. And then the trial court held that it had personal jurisdiction over Int'l Shoe. This was the Washington State Trial Court. And then Int'l Shoe appeals. The Court of Appeals affirms the trial court. There is personal jurisdiction. Then Int'l Shoe appeals again. It goes to the Washington Supreme Court. They affirm the Court of Appeals. Yes, there's personal jurisdiction. And if you think that Int'l Shoe is going to end up winning at the U.S. Supreme Court, you would be wrong, because the Supreme Court holds that the Washington state courts have personal jurisdiction over Int'l Shoe. So they give a lot of really informative, helpful analysis of the personal jurisdiction question here and some really, really crucial guidelines for the future of personal jurisdiction that pop up time and again in these personal jurisdiction cases. So whether due process is satisfied or not depends on the quality and the nature of the activity in relation to the fair and orderly administration of the laws. To the extent that corporations exercise privileges of conducting business activity in state, they enjoy benefit and protection of the laws, and that gives rise to obligation. And by obligation, they mean the obligation to defend themselves in a lawsuit when they get sued for their activity there. It's a part of being held accountable. You reap the benefits of being in one state, the benefit of the protection of the laws there, and you are expected to deal with the drawbacks of defending a suit within that state. It wouldn't make much sense to have you just benefit from the laws of a certain state while being completely immune from suit for lack of personal jurisdiction. So, application. Int'l Shoe's activities were not irregular or casual in the state. They're systematic and continuous throughout the years in question, and they've established such contacts with the state that the particular form of substituted service adopted there gives reasonable assurance that the notice will be actual. That is to say, Int'l Shoe knew that they could be subject to suit there. It's not unreasonable. We're not bombing them with this nuclear surprise of a lawsuit or anything like that. No, Int'l Shoe knew that this was coming. So, the bottom line is this. This is the black letter law. A court has no personal jurisdiction over an individual unless that person has minimum contacts with the forum state and the lawsuit does not offend traditional notions of fair play and substantial justice. So those words are going to come up time and again. Fair play and substantial justice, very relevant. The Supreme Court justices love bringing this up. They also love bringing up the minimum contacts issue. I mean, especially if you read some of Justice Brennan's opinions later on, he loves Int'l Shoe and the Int'l Shoe analysis. So this is very important. This case means a lot for personal jurisdiction, and it didn't overrule Pennoyer, but it really supplemented it with something very meaningful. And now Pennoyer versus Neff's application is a lot more narrow. It's still good law, but it applies to a more narrow set of circumstances. Where Int'l Shoe comes in, it's like, yeah, we're going to recognize the modern reality of the world. That, no, they might not be physically located in the state, but it still is fair. It comports with fair play and substantial justice to have them defend a lawsuit in the state, even though they're not physically there. So yeah, that is Int'l Shoe Co. versus Washington for you. If you liked this video or found it helpful or interesting, insightful, please leave a like, comment, and subscribe. I really do appreciate it. Let's grow this channel. Let's spread knowledge of civil procedure and the law. And I will speak to you in the next video. Thank you for watching.